needs to show his video.
Great. So good afternoon, everybody. Today is September 24th. We are Board on Professional Responsibility. We are convened in the matter of Lateef S. Doman. This is board docket number 17-59, disciplinary docket numbers 2010-50 and 2012 Anyone else getting that? I think it might be, Mr. Linkett, I think it might be a problem with your connection where I'm not sure what it is. It sounds like maybe someone's vacuuming or.
No, there's no one in, no, there's no one here.
Using a blender, I don't know.
No, there's no one here. I'm nowhere near a blender in my office.
Great. Well, let's hope it resolves itself. Okay, so before everybody identifies themselves for the record, we are, as you've noticed, on Zoom. A couple of just ground rules for the oral argument, given that it's virtual and on Zoom. First, if you're not speaking, please mute yourself. For the council who are arguing, try to keep an eye on board members. If a board member has a question, they will try to interrupt you. Sometimes, just the way the technology works with people talking over each other, it can be hard to tell when someone's trying to ask a question. So keep an eye out. If a board member has their hand up, that means they're trying to get your attention to ask a question. I will play traffic cop to the extent that I can. So would the parties please identify themselves for the record? Start with disciplinary counsel.
Miles Link for the Office of Disciplinary Counsel.
For a respondent.
Daryl Davis, actually joined by Lateef Doman for respondent.
Mr. Davis, will you be arguing?
Mr. Doman will make the argument.
Okay, all right, thank you. Well, one other thing, I think as everybody probably noticed, I issued an order earlier this week directing folks during the argument not to use client names. Instead, refer to clients to the extent that's necessary in a way that doesn't reveal the name of a client, initials or some other. I know both disciplinary counsel and the respondent filed objections. It seemed to me disciplinary counsel had more exceptions than respondent. I don't know if have you discussed who's going to argue first?
And disciplinary counsel takes the view that we filed the initial objections, exceptions. We should argue first. We also, Mr. Chair, take the view that we should have had the right of last briefing reply. And in addition to granting the protective order, literally on the eve of this hearing, the board granted a surreply to respondents, giving them 23,000 words exactly, and that at the very eve of this hearing. And so we frankly would move the board to grant us an opportunity, if necessary, to file our own reply.
Sure. I will say that of that reply being was regrettable and apologize for that. I understand your position. I think why don't we do the argument? If you believe you have a motion to file, you can file a motion afterwards and we can address it then. Mr. Doman, disciplinary counsel is asked to go first. That does strike me as reasonable. They've got a lot of exceptions and they accepted first. Any objection to that?
No, we have no objection.
Great. Mr. Link, you've got 20 minutes. You can reserve time for rebuttal. How much would you like?
I'd like to reserve 5 minutes for rebuttal.
Great. As soon as the clock is ready, you can begin when you're ready.
Thank you very much.
Not sure, Mr. Turner, is the clock set? Sorry, Mr. Link, I don't mean to hold you up. Mr. Turner, are we, I guess you're muted, so I'm not sure I'd hear if you,
One moment, Mr. Chair.
of course.
Seem to be having a bit of technical difficulty here, Mr. Chair.
Do you think it's likely to resolve soon? I mean, alternatively, I can look off the Zoom clock, and I don't know, Mr. Link, if you're able to see that. Sorry, you're muted again. Sorry. Mr. Link, you're muted.
I'm sorry. I'm not able to see the Zoom clock, but if you were to, or if someone were to sort of hold up a sign or something letting me know when I had 10 minutes and 5 minutes, that would be fine.
I'll do, this will be the 5-minute signal, and then I'll let you know when time is up, although, we're not super strict on time limits anyway. So with that, Mr. Link, when you're ready.
Thank you very much. This case has some unusual dimensions to it. Probably the most unusual is the Office of Disciplinary Counsel challenges the hearing committee's report and recommendation, not just on its findings and conclusions, which we think are not supported by substantial evidence, but on the bias shown by the hearing committee members in their deliberations. This is sort of an extraordinary report, and the bias demonstrated by the 2 attorney members of the committee is itself extraordinary. This bias,
you
yes, ma'am.
argue that the hearing committee is biased, but what errors did that bias lead to? And if we were to find bias, what does that mean for the board's review?
I will go over specific findings and conclusions that I think were affected by the bias. And I think the board has options available to it. The board can review the record on its own, and under the board's own rules, it has the authority to do that. It can do that under 13.7 and review the record and determine whether there are findings that are supported by clear and convincing evidence by disciplinary counsel. Alternatively, the board can remand this case to a different hearing committee and let another hearing committee hear the evidence, hear the testimony, review the record, and make its own findings a fact. We understand, because we are in a number of these proceedings, that sometimes we will convince a hearing committee by clear and convincing evidence that our charges are supported by clear and convincing evidence. Sometimes we won't, and we understand that sometimes it's a closer call than other times. But in this case, where you have clear, really from their own mouths, from the hearing committee, that their view of the record was tainted by their bias, really, you have no choice but to do that. I want to just, one of the cases.
Before we get there, I guess I've got kind of a maybe logically prior question. The bias you're talking about, it looks like it's from your briefs, it's restricted to that statement in the concurrence. Does disciplinary counsel take the position that the proceedings were flawed, that there were evidentiary rulings that went against you because of bias, or is it just with respect to the conclusions that were drawn from the evidence that came in during the hearing?
Well, we take the view that the bias tainted the way the Assistant Disciplinary Counsel was treated by the hearing committee. We think that did affect some of the rulings, but most importantly, we think it affected how they viewed the record, and they're putting a spin on the record that was unsupported by the evidence that was presented to them.
I hear you. Those are two very different, get to two very different kinds for you, right? I mean, if it's merely, and I don't mean merely lightly, but if it's just that they looked at the evidence that came in and they put a spin on it, and that spin was biased, the conclusions they drew from the evidence that came in were flawed, then it does look like, we could, one option, and maybe the option that suggests itself most readily, is that we review the record ourselves as we're entitled to under the board rules. If your position, though, is that evidence would have come in that didn't come in because of the bias, or came in that shouldn't have because of the bias you're talking about, then it looks like our ability to do that review now is substantially limited, that you got a bad hearing rather than bad conclusions off of the hearing. And I take it from your brief, you're really making the bad conclusions argument, not the bad hearing argument. I just want to make sure that's your position.
Thank you. We're making the hearing resulted in bad conclusions and bad findings. So because the hearing resulted in bad conclusions and bad findings, and not bad because we disagree with them, but bad because they don't track the record evidence. That's our point. And they don't track the record evidence because the hearing, the majority of the hearing committee took the view that they were going to, they had a view of this respondent, and they took the view that that they simply were not going to find serious violations of the ethics rules by this respondent.
So, Mr. Links, my question, and I think this question has previously been asked, and you said you would get to it, and I think it might be important for you to get to it now, which is, I don't identify in your brief the factual findings that you're challenging. I understand that you're challenging conclusions. I do get that from your brief. And so if you could point to us, and I would start with count one, what specifically in count one are you saying are findings that the hearing committee got wrong, that aren't, that don't have substantial evidence supporting them?
Well, okay, findings of fact 28, the failure to refuse discovery requests, the hearing committee said were excused by holidays and other obligations. Lawyers face those challenges all the time. That doesn't excuse a lawyer's obligation to comply with discovery requests or to seek some relief from doing that. Finding of fact 33, Mr. Doman said he had a good faith belief as to when his written discovery requests had to be issued. In fact, there was no basis for such a belief, there was no basis that was a good faith belief. That was, in effect, his wishful thinking. He wanted to think that if you're saying somebody has a good faith belief, what was that based on when in fact the very order he had prepared for the administrative law judge to sign was itself so ambiguous that in fact both the administrative law judge and the opposing counsel interpreted it differently.
What is your evidence of, Mr. Link, I'm sorry to interrupt you, but I want to go back. I do not want to accept, even for the sake of argument, that there's been bias shown here. What is your evidence in the record?
My evidence in the record is as follows. In this concurring opinion, which they voluntarily wrote and submitted, the attorney members of the hearing committee said, and I quote, "While it may be presumptuous to say this, I know it to be a widely held view of members of our bar that disciplinary counsel is difficult to deal with and overzealous in pursuit of minor transgressions and mere mistakes."
Is that your only, is that?
No,
your
that's not my only example, but I want to explain that example.
No, I would like to know, for example, do you have places in the transcript, actual questioning from the members? Do you have, you made a reference to the treatment of the prosecuting assistant disciplinary counsel. Do you have examples of that we could
I
look at?
don't have examples of that with me right now. And in fact, that might be something to submit in a future brief. But I ask you to look at the record, look at the transcript itself, and you will find it. There are, for example, again, in this concurring opinion, the argument that the disciplinary counsel, I'm sorry, I can't, looking for it right now, and I don't have it. Our public member understandably expressed his concern. This was repeatedly during the proceedings and our deliberations about the level of candor and cooperation shown by respondent. What was the response of the attorney members? Well, respondent might have taken a less defensive posture. They were, as we said, going out of their way to defend and support the respondent in these proceedings. And then in my experience as hearing committees and as a contact member reviewing disciplinary counsel files, many complaints come from disgruntled clients who expected more than was reasonable and used the disciplinary system to further their own unreasonable or in some cases unsavory objectives.
Isn't that in favor of disciplinary counsel, that last statement? Isn't that last statement regarding disgruntled clients, isn't that a bias that's more in favor of disciplinary counsel?
No, because they use the disciplinary system to further their own unreasonable and in some cases unsavory objections. He's saying he's using, or these clients are using the disciplinary system. But where does that come from? And I want to go back to this case that respondent relies on. And I said in our letter, we would comment on it. That's the Sibley v. Mount Albans case dealing with judicial bias. One of the things the court said is that to show bias, you need to show sort of some extra.
We have 5 minutes left in this. I just want to let you know you are on time. Sorry to cut you off there. 10 minutes in, 5 minutes left. You're fine. Keep talking.
Okay. And what we're suggesting here is these are evidence of extrajudicial, outside of the four corners of this hearing, bias they brought into the hearing. This notion that there's somehow clients who have unsavory objectives, how does that relate to this particular individual? It does not. So that taken together is evidence of bias brought into this proceeding by these hearing committee members, and it tainted their judgment and their view of the evidence in this case.
Mr. Link, I have a hypothetical for you. When I took legal ethics, I remember my legal ethics professor saying that you should never represent family and friends because it always, not always, but it frequently results in ethics charges because it's just how it is. And that's everybody knows that in the ethics world, don't represent family and friends. All right, so now I'm a hearing committee member and I have a case in front of me in which someone is representing a friend and big mistakes were made. And I start my hearing committee report by saying, it's widely known that you do not represent family and friends because you end up with ethics violations. And here we see that play out. And I then detail my findings to say that the lawyer violated all kinds of rules in representing a friend. Is that bias?
I would have to see the report and see the hearing. I don't know that I would call that sort of bias necessarily, although I would suggest that if you brought into the, for example, one can say as a general matter, you shouldn't represent family or friends. Now, specifically in this case, what happened? And was that general feeling supported or was it not supported? Did the matter? And so what I would suggest is, frankly, I think it would be inappropriate to make that general comment, but I would ask, how did the hearing committee member apply their analysis to the facts and the evidence and the testimony that was brought before them. That's the relevant question.
And I think that's precisely the question we're struggling with here today. You've pointed out a statement in the concurrence that probably wasn't a good statement to make. It was like the one I gave in my hypothetical. So we're struggling, and this is why you're getting these questions, is
No,
we're
it's fine.
struggling with where's the evidence that that statement was actually a bias as opposed to just not a very good statement to make.
Fair enough. One of the, I wanted to go through the findings and conclusions we challenged, but one of them goes to whether or not Mr. Doman ever fully articulated before the disciplinary council an objection that he was not going to respond to the subpoena for his bank records because of attorney-client privilege or confidentiality. And in fact, he never indicated that that was a basis upon which he was not going to respond to information. In one letter, he referenced that he thought some of the information might have been attorney-client, but he never said, I'm not going to produce any documents on that basis. And the real issue he raised throughout the investigatory period was the burdensomeness he alleged and the scope. He thought the scope was too large. The hearing committee, nonetheless, in a sense, gave him a pass on that and said, well, that's, that sort of, he could have done better. He could have been clearer. In fact, for this hearing committee to have said he could have been clearer, that wasn't an issue at all. And it didn't matter because under In Re Confidential, the court has said that's not the basis upon which you can refuse to comply with a subpoena.
Mr. Link, what
did-
did ODC do? What did ODC do to confer with the respondent and get him to produce those documents in the investigatory phase of this matter? And why didn't you file? You're muted. You're muted.
I'm sorry. So did you hear what I...
Were any papers filed? Motions filed to compel production?
Very good question. Motions were not filed to compel production because we had no reason to think he was not going to produce. What did he do? He asked for multiple extensions of time, and we granted him extensions of time. Look at the exhibits. His letter to us, it's our disciplinary counsel exhibit 26, his letter in disciplinary counsel exhibit 28, 28A. When he asked for more time, we granted him more time. And we thought we would be getting the documents in the fullness of time. We never got the documents.
What would the mechanism have been to file a motion to compel if you weren't getting what you needed? Because simply waiting for him to do what you expected him to do, does that preserve your ability to sort of contest the lack of production at this stage?
Well, the court has said in In Re Artis that you don't have to file a motion to compel to nonetheless find a violation of 8.4D, a failure to cooperate, substantially impede the administration of justice. And that's what we're alleging he did here. By failing to produce the documents and by failing even to articulate why, fully articulate why he wasn't going to produce them, had he done so, we would then have told him that, in fact, that was not a legitimate basis not to produce the documents, and he still would have had to produce them. He didn't file a motion to. He could have filed a motion for a protective order or to quash the subpoena. He didn't, and the reason why he didn't is because he did file a motion to quash the subpoena we delivered to the bank, and he failed. He lost that motion. And having lost that motion, he did not want to lose a second motion. He didn't want a court telling him he had to do it.
If we're understanding your argument correctly, Mr. Link, are you saying that basically you asked for documents, he said, no, I think this is overbroad, I'm not going to produce them, right? And then you said, well, he should have anyway, but yet...
No, we think he should have produced them. but the discussion around what he should produce, what the scope of that should be, resolved around the scope of production and around the duration. There was never an issue about, well, should we redact names, for example, which has become the subject of his protective orders in this proceeding. Okay, can I make one other point? One of the most interesting findings the hearing committee made is when one of our allegations was dishonesty under 8.1. He was dishonest in his production, in his meetings with disciplinary counsel. He purported to hand over a document.
Mr. Link, I'm glad you raised that because I really want to make sure that we get, I'm sorry, go ahead, Chairman.
We're out of time. We're going to keep going. Ms. Priam, you have been the model of patience waiting to break in. I just wanted to let everybody know where we are with respect to time. Please go ahead.
I just want to make sure that we get to this issue, and which is dealing with the bank record. So focusing on Exhibit 26B, the disciplinary counsel is arguing that the hearing committee should have found that respondent falsely testified about this document, that it was generated by the bank and that it was actually a quickened document. I want to make sure that we hear from you about the threshold question of standard of review. Does Bradley allow the board and the court to consider the truthfulness of respondent's testimony de novo whenever the testimony is material to an issue in a disciplinary case, or is Bradley more limited? Does Bradley permit us to review the truthfulness of his testimony regarding the bank record?
I think Bradley does, and I think this board has taken the position that it does, particularly with respect to respondent's testimony and with respect to respondent's credibility. And this relates to findings of fact 155 to 158, where the hearing committee found that this document might have been produced by the bank, and they essentially discounted the bank officer's testimony that he had never seen this document before. Yet in the briefs Mr. Doman has filed in this proceeding, he has all but admitted he produced the document. And he says the only issue now is whether it was accurate, At the hearing, the question of, and the hearing committee focuses on this, well, did he own a Quicken file to produce these types of documents? That's irrelevant as to whether or not the document was produced either by him or under his direction or at his instigation. The point is, when it was submitted to disciplinary counsel, he told us it was, in 2012, it was prepared by the bank. And that provenance is what gave the document legitimacy. Our investigator found out it could not have been produced by the bank because it included transactions the bank would have known nothing about. The hearing committee ignored that testimony.
But Mr. Link, is this a credibility determination to which we defer to the hearing committee if it's supported by substantial evidence in the record? Or do we review this de novo because it's a legal conclusion and a determination of ultimate facts?
I think on this issue, it's a determination of ultimate facts, and you can review it de novo. And I would argue you're in a better position to review it de novo because you now have his brief in which he often admits the issue here is not whether it was prepared by the bank. The issue is whether those transactions took place at all. Basically, he's abandoning his testimony that he gave at the hearing. That speaks for itself.
Mr. Link,
so when you say we can review it de novo, you're relying on Bradley?
I'm relying on Bradley, yes.
Okay, thank you.
Mr. Link, I've got just a perhaps basic factual question about the competence issue, the competence charge. Because I'm looking at your brief and the things that you explained were reasons that you violated 1.1. I totally get your argument. I'm with you that the standard is not a malpractice standard. You can an attorney can be not competent, can violate 1.1 if the attorney's got a loser of a case. I understand that point. I guess what I'm wondering is where for the specific incidents of not competent performance that you talk about in your brief, your expert supports those.
Well, for that, I would ask you to go and look at our expert's testimony at the hearing. The hearing committee at findings 150, excuse me.
50?
Yes, the hearing committee sort of cherry picked the Mr. Gilbert's testimony at findings of fact 56, 70 to 72, and 74 to 77. And they basically took that out of context. Mr. Gilbert said the standard of care or the standard exhibited by respondent in representing this client was below the standard that should have been utilized. And the hearing committee basically didn't want to hear that. That, by the way, is another example, you asked before, of the hearing committee's bias. Read Judge Gilbert's testimony and then compare it with the cherry picking the hearing committee did with respect to that testimony. In fact, if you read the hearing committee report, it's almost as if Mr. Gilbert is testifying for Mr. Doman, which was not the case. In terms of the competence issue, there are so many factors there. It was Mr. Doman who recommended to the client that they take an appeal to the DC Circuit after they had lost in the administrative proceeding and after they had lost in the district court.
It wasn't an appeal to the circuit. It was to file her claim as an initial matter in the federal district court. And that would have been the way to preserve her action.
No, they with respect, Ms. Sargent, they went from the administrative proceeding to the district court. The case was dismissed in the district court. The government filed a motion to dismiss or in the alternative for summary judgment. It was granted with prejudice by the judge, and the judge saying because they failed to submit evidence to support their claims. And in that proceeding, as in the administrative proceeding, every time limit that the court set was missed by this respondent.
Maybe you misspoke. Maybe you misspoke because you said an appeal to the circuit.
No, respondent recommended to the client after the case was dismissed by the district court that she take a further appeal to the DC Circuit, and she ultimately said no. What respondent? Well, I mean, there were many other options, and one of the most interesting things here, applying the incorrect standard that the hearing committee did, that this was a malpractice case, they said, well, this case was unwinnable. Well, if that was the case, applying their own logic, why should it have gone to the district court and from the district court gone to the Court of Appeals? There are options under Rule 1.16 for an attorney to step back and say to the client, and sometimes, as we all know, the most important thing an attorney can say to a client is no. By its own logic, the hearing committee should have said something was wrong here.
Mr. I have a quick question on commingling, because we haven't touched on that yet. And my question to you is, I read your brief as saying that the hearing committee erred because they did not recognize that, and I'm on page 37 of your brief, you give an example of a case where money went into the trust account that belonged to respondent. The next sentence says that it says the board chose to ignore, I think you meant committee. The committee chose to ignore this commingling of entrusted client funds with personal funds. My question to you is, it seems like throughout the briefing, the first element, you've identified funds that belong to respondent, exists. My question to you is, where's the second element of, and that money was in the same account as funds that belonged to the client or a third party?
And
I think
from April,
having money in a trust account that belongs to respondent isn't enough.
Right. From April 2011 to September 2012, he separately deposited earned and unearned fees into his IOLTA account. Now, he also testified that he thought his operating account was his trust account, and he overdrew that account 13 times and the bank had to close it. So even accepting his testimony that he thought that was his trust account, he shouldn't have overdrawn it 13 times. But with respect to his IOLTA account, which he overdrew in September of 2012, he had the settlement funds from one of his clients in that account, at the same time that he took from that account money to pay his office and personal expenses. He paid his website development, he paid for political donation, and he paid multiple employee payroll expenses from that account. That's our Exhibit 28.
And was that during the period in which he was writing checks that he thought were coming out of the operating account, but were in fact coming from the trust account because of the bank error?
It's interesting. They overlap to some extent, although not completely. But what's interesting about the bank error, and this goes to his failure to keep records, one of the things the hearing committee said, well, one of its sort of, if this were not such a serious proceeding, it would be almost amusing. They said, well, he didn't find the error because he didn't open his mail and reconcile his bank statements with his deposits and withdrawals. And then the hearing committee says, but this case isn't about his mail opening practices, as if that's sort of a throwaway line for a late night talk show. This hearing is about a lawyer handling funds as a fiduciary. That's what commingling is about. As a fiduciary, you have an obligation to handle the funds responsibly, and he failed to do that. The evidence of commingling is clear. And again, we refer you to the record to look at the documents and see.
Okay, so I've looked at them and I'm going to recommend that on rebuttal, if you could just give me a site that shows where there is the actual his funds and the client funds together. If you can, I think that would be great, because I do want to make sure I get that clear in my head.
We are 30 minutes into a 15-minute argument. So at this point, we will, and thank you very much, Mr. Link. We'll turn things over to the respondent. The clock is working. You've got 20 minutes. Whenever you're ready, please begin, Mr. Doman.
Thank you, Mr. Chairman. Good afternoon. May it please the members of the board. My name is Lateef Doman. I have been a member in good standing of this bar since 2001, and I am the respondent in this matter. This prosecution comes from two flawed disciplinary investigations. In the case on appeal involving the federal employment discrimination representation, disciplinary counsel's investigation was incomplete. Mr. Link just confirmed that the investigation was incomplete by arguing that I missed multiple deadlines in the federal employment discrimination case. The record is clear. The hearing committee found that I missed one deadline because of a fax was sent to me that went to an e-fax, and I missed it. And I immediately filed an extension of time, which was granted for good cause. The court issued an extension of time and implemented a new order. And as a result, I followed all the deadlines for the new order. So the petition is suggesting that I missed all the deadlines of the old defunct order that was replaced by the extension of time order. It's absurd. But
did you, Mr. Doman, did you drafted the order yourself, right? You drafted it as a proposed order.
Absolutely, and there was no confusion about the deadline. The court understood that it was the deadline was extended by 30 days. I understood that. Opposing counsel was trying to fight because she lost the motion for extension of time and tried to claim that she misunderstood. But that wasn't the issue at all. It was very clear from the order what I was requesting.
But am I wrong to understand that as an initial matter, should you have extended the deadline for you to have filed your initial discovery requests?
No, because I filed the motion nunc pro tunc, and a nunc pro tunc motion would allow for the court to consider that it was filed out of time, but nonetheless, there was good cause for it. And the administrative judge determined that there was good cause because the fax went to my e-fax, and I didn't realize because it went to my junk mail.
But are you disputing the question that Ms. Sargent was asking, which is that you correct me if I'm wrong, but you ultimately were not able to propound discovery because you didn't extend the deadline to initiate discovery at the EEOC level. Is that correct or incorrect?
That's partially correct. The court, the administrative judge determined that we had not timely met the deadline to meet under the new deadline. Well, he never determined that. I had filed it, I had served it. Opposing counsel received it in transit, but she filed her motion saying that I did not serve it before she received it, which was by the deadline. So her motion suggested I meet the deadline.
No, but wait. There's two different things. There's two different things, and I want to make sure that we're clear here. Okay. One is to extend the discovery period, right? You moved for an extension of the discovery period, but you never moved for an extension to initiate discovery, because you have to initiate discovery within, what is it, like 30 days after you initiate an EEOC case, that you have, like, after the acknowledgement order comes out, you have to initiate it, right? So you never moved for that date. So that's what precluded you ultimately from propounding discovery in that case. Is that correct or incorrect?
That's incorrect.
Okay, tell me why that's incorrect.
Right. If you look at the motion that the judge signed in whole, he didn't change a thing. I said in that motion 4 separate times, we are seeking the extension of all deadlines in this case, all deadlines, including the time to issue discovery, the time to respond to discovery, and any other deadlines in this case. Please extend every deadline by 30 days.
But ultimately, the court actually ordered, in a separate order, didn't the court find that you failed to request or initiate discovery in a timely manner?
The judge, in a subsequent erroneous decision, did find that.
Okay.
But the record is clear that I timely requested, or I requested an extension of time, nunc pro tunc. The judge granted that extension for 30 days. And under that order, where he extended the order, I did not miss any deadlines. And so when the petition claims that I missed every deadline in the case, that's simply untrue. I missed an initial deadline at the outset of the case because of a technical error that the AJ said I had demonstrated good cause for the extension of time. Ultimately, the case was dismissed on a discovery motion because the judge ruled prematurely that I had not responded to the motion to dismiss the case. As you know, Mr. Hora, when you receive an order in the EEOC, you have 10 days to respond to a motion. I received the court's order saying that I had 10 days to respond to this motion for sanctions. On the 8th day after I received that motion, the judge ruled that I had not replied. The judge ruled that I had not responded to the motion, and he determined that my client was not opposing the motion, and therefore he determined that we were not entitled to discovery. So on the judge's error, his premature determination that I was not opposing the motion, he dismissed my client's case, which was error. I filed immediately a motion for reconsideration. He concluded that that was untimely too, even though I filed that just days after I had filed the opposition to the motion for sanctions. So the judge erred, and the dismissal was not my fault. But the saving grace was that.
Billman?
Yes.
I want to turn to the bank record dialogue that I was having with Mr. Link. Mr. Link, in response to my question, said that in your brief you had all but admitted that you produced the bank record and not the bank. Is Mr. Link right? And if he's not, why is he wrong?
He is not right. The testimony about the transaction list, the transaction list is simply a document that reflects all of the transactions that you would see on a bank statement. And there were 3 additional transactions that were added to the document that would not be reflected in the bank statements. I submitted that document in response to an initial subpoena request. I made no affirmative statements during the investigation about who created the document. I did not think that was relevant. During the investigation, during the years of the investigation, no one ever asked me who created the document. It was in the hearing. It was at the hearing on the stand. Opposing counsel, Ms. Tate, was saying that you created this document. And as she was saying that, asking me a question, I was like, well, I just corrected her. I was like, no, I didn't create this document. I got it from the bank. And then suddenly, I guess that is the basis for this claim that I made a false statement on the stand. That's simply not true. I was just correcting her misunderstanding, but I never made an affirmative statement at any point during the investigation such that I contradicted myself on the stand that this document was created by someone other than the bank. Now, with regard to
Why were you
Mr.
willing
Lank's
to
statement-
produce this bank statement but not respond to disciplinary counsel's request for documents associated with your bank account, your what you could call your personal records?
Yes, the transaction list focused solely on my IOTA account. And when I signed up for the IOTA account, it was understood that that information in that IOTA account would be accessible by the bar per the agreement. But the information in my files, I signed no agreement with regard to that. My client certainly did not consent to that. And certainly the information in the bank statement, while it has the transaction information, it contains quite a bit of confidential information, but I didn't think it was to the extent that they could identify or pierce my client's confidences in that regard. So that's why I provided that document without providing the additional supporting records.
What would be the difference though between the documents that ODC was looking to get from you that you didn't provide to them and the bank statement? What information specifically is contained in the documents that you declined to provide that you won't find also in the bank statement that was produced, assuming that is a bank statement?
Right. Well, let's be clear. Disciplinary counsel had all of my bank statements for the entire 19 months that I had that they pursued for the account, both my operating account and the IOTA account. So they had quite a bit of information. In addition to that, they had the transaction list that I provided, which verified all of the transactions that the bank identified for them. The materials that Mr. Anderson testified, the forensic investigator testified that the disciplinary counsel was interested in getting were my retainer agreements, my settlement agreements, my invoices, my communications with my clients about the agreements with regard to my settlement agreements and my retainer fees. All of that information it's very, very clear under DC ethics rules, under our rules, that information is privileged. Our rule 1.6.
Well, what is your interpretation of In Re Confidential, the cases that were cited by ODC then? How do you respond to the argument that it's pretty clear that in a disciplinary proceeding, you're not allowed to assert attorney-client privilege to withhold documents?
I disagree with that interpretation. I think Rule 8.1b says that when disciplinary counsel asks a lawyer to produce documents, the lawyer has a responsibility to respond, except for those documents that would violate Rule 1.6. So there is an expectation that I want to cooperate, and I tried to cooperate as much as I could, but 1.6 says that I just simply cannot violate the duty of confidentiality that I owe to my clients. I'm sorry.
That's an opinion of the Court of Appeals. Like, you don't get to just disagree with it and ignore it. That's not how it works.
I don't disagree with the In Re Confidential, and that's not what I was suggesting. If you heard that, I apologize. With regard to Mr. Horace's question, with regard to In Re Confidential, In Re Confidential simply establishes what the process is for when parties have a dispute about the scope of the investigation. I did not have the opportunity to go before the Court of Appeals as they did in Re Confidential. In Re Confidential involved a motion to enforce and the subpoena that was issued. And that subpoena ultimately only identified 3 complainants who were at issue. So In Re Confidential had identified specific complainants whose information needed to be turned over. And it was being considered, the court was considering the constitutional limitations of the particular subpoena that was issued to that particular respondent. In my case, there was no subpoena that was issued to me that was specific to any client, specific to any transaction, or specific to any particular misconduct. I had no idea where to start. And so I needed guidance from the Court of Appeals to identify where the limitations were on disciplinary counsel's right to investigate my client's files.
Well, but the rules say that they've got a right to investigate your files. And in Re Confidential, I guess I see it the way, you're sort of reading it. Well, the facts were different in that case than they are in your case in some ways, but it looks like it makes it pretty clear that you've got to hand stuff over, even if it contains privileged information. You can, bar counsel they're just quoting the rules. Bar counsel may investigate all matters involving alleged misconduct by an attorney, which may come to the attention of bar counsel or the board from any source whatsoever. Like I guess I don't get your argument.
What is the
Yes.
ambiguity there?
I would say, I would point out Board Rule 10, Section 8. All investigations, whether upon a complaint or otherwise, shall be conducted by disciplinary counsel. An attorney under investigation has an obligation to respond to disciplinary counsel's written inquiries in the conduct of an investigation subject to constitutional limitations. And in order for us to determine whether it's subject, I need to be able to get before a court of competent jurisdiction. As I explained in the filings, it's not just a limitation under 1.6e. They were asking for settlement agreements. My settlement agreements all have non-disclosure agreements in them. They all have non-disparagement agreements in them. So in order to, I'm sorry, I'm cutting someone off.
Mr. Dillon, what's the constitutional argument here?
The constitutional argument is that under the Fifth Amendment, an employee, the Fifth and Sixth Amendment, the duty of confidentiality is owed to employees because the duty of confidentiality supports the attorney-client relationship.
Oh, that's self-incrimination.
I said the Fifth and Sixth. I said the Fifth and Sixth, not just the Fifth Amendment.
The right to counsel in a criminal case?
I'm sorry, just the right to counsel, period.
Well, but
Do you have any case support that the Fifth and Sixth Amendment apply specifically in this context? Because I think that might be new to a few of us.
Okay, well, I may be misspeaking. I may be pointing out the wrong, but certainly, my clients have a right to be confident that the confidences that they share with me.
Okay, sure, but why couldn't you do what people do when there's a discovery dispute over privileged information? You produce a privilege log. Right.
So I think the DC ethics opinions make it very clear, particularly an ABA opinion that makes it very clear. An ABA opinion that Mr. Link wrote that basically says there are a series of things that a lawyer has to do before they even begin to start to disclose information. You have to get consent of every client whose information you're going to be revealing. If I'm going to be revealing defendants' information that's been agreed to under confidentiality of defendants, I have to get their agreement as well. There are a series of steps that are very, very complicated. And I was not.
But usually these settlement agreements provide for the disclosure of these things as required under law. And I think that the argument here is that the law requires you to turn that over. But my question is by producing some documents and not others, haven't you waived the ability to assert any sort of privilege, assuming that for the sake of argument that you have that, right?
No, I don't think so. I think that the partial waiver rule is that if you partially waive some confidential information, but if you produce information that's not confidential, I don't know that you necessarily are waiving other material. So my partial production, I was attempting to comply to the extent that I could by producing what I thought was reasonable and appropriate, but I was not able to produce the information that I believe was confidential.
Mr. Doman, in response to ODC's November 5 initial letter request with information and subpoenas, your response cited attorney-client privilege as a reason why you needed additional time to respond. Can you point us to anywhere in the record where you either raised a written objection based on attorney-client privilege or otherwise told ODC that you were not producing documents that were privileged?
Yes, and no less than 6 times I communicated in writing to disciplinary counsel that I had in my possession documents that I believed contained confidential information. No less than 6 times, and I apologize, I'm looking for the page citation in one of my briefs in which I did that. Yes, and I will find those in a second as I'm standing here, but in particular, there is no dispute that I objected in writing because I filed a motion to quash the subpoena that was issued to the bank for the bank's records. That
I want you to put that to one side because moving to quash a third party subpoena in my mind is different. You don't have any other means of objecting to it. where it's a subpoena directed to you, you have the choice of objecting or moving for protective order. And what I'm trying to understand is where in the record you raised an objection because you chose not to move for a protective order.
Right. Well, I was going before you cut me off there. I wanted to just point out with regard to that motion to quash with regard to the third party. It is. I promise you, it is relevant, and that is because the hearing committee chairperson who decided the motion to quash said in that motion, Mr. Doman made more objections to the subpoena that was issued by disciplinary counsel to him in this motion than he did in the motion than he did with regard to the subpoena that was issued to the bank. So I very clearly communicated the things that I had already been saying in writing in the letters that I had sent to disciplinary counsel as I was asking for extensions of time and as I was talking to lawyers trying to figure out what documents I needed to produce. But at the same time, I was on the phone with the Office of Disciplinary Counsel, communicating my concerns, I was trying to, like, can you reduce this to 3 months so that at least I will have a manageable number of clients that I would have to call or violate? Can you at least explain to me what particular documents you want? Because you sending me the subpoena saying, please send me all of the supporting documents for every transaction for the last 19 months or the last 12 months in this IOTA is just too broad. And it was just far too much information for me to provide. And
Mr. Doman, I'm sorry, I'll cut you off one more time because with the time we have remaining, I do want to ask you a question about you having taken exception to the hearing committee's finding of a rule keeping violation. The purpose of the complete records requirement is so that the documentary record itself tells the full story of how the attorney handled client and third-party funds. In ODC's Exhibit 27A, you responded in January of 2014 to their information requests at Exhibit 27, including requests 6 and 7 regarding deposits related to different of your client matters. And as to those two requests, your response in 27A was that after making a diligent effort to reconstruct events that occurred more than a year ago, I do not remember the circumstances. My question to you is this: why are your responses to those two requests not sufficient evidence of themselves of a record keeping a violation, combined with your testimony that you did not keep unified spreadsheets, ledgers, or other standardized sets of documents?
That particular subpoena was sent to me, and it was and after my series of emails and letters to opposing counsel trying to get some clarification for what types of information that they wanted so that I could try to narrow what should be produced. That subpoena asked for this. It said, by client file, we mean each and every document in your possession associated with the representation, including but not limited to any retainer agreements, all bills, invoices, accountings, financial records, settlement sheets, timesheets, records, worksheets, pleadings, notes, and memoranda to the file, telephone messages and logs, writing on Post-it notes, electronic mail, and audio tapes.
Mr. Doman,
I could not produce all of that, and so my answer was I can't remember all of that. I've looked at it, and the circumstances of this particular transaction, which was outside of the transaction that was subpoena that was originally sent to me. I did my best to try to respond, but there was simply too much information to be able to accurately answer that question.
Could I ask you to mute for a second? Sorry, I think. Thank you. Sorry, I don't know, Ms. Preheim or Mr. Doman, if you had more.
No, thank you.
Great. Do you want to take 15 seconds, wrap up, and then we'll.
Yes. The Office of Disciplinary Counsel's mission is to protect the public from unscrupulous lawyers and to protect lawyers from unfounded complaints. Regardless of whose interest it's protecting, disciplinary counsel must conduct an investigation in a principled way, in a manner that's consistent with the laws and the rules of this jurisdiction. That doesn't mean that disciplinary gets to decide what factual allegations it wants to suppress in order to create a likelihood of getting a charge approved, because disciplinary counsel simply didn't have the facts to bring count one. And that's what the hearing committee found in its very strong and substantial hearing committee report, that the charges in count one probably shouldn't have been brought. And that doesn't mean the disciplinary council gets to shift the burden onto me to prove innocence of charges while I was hamstrung by the duty of confidentiality. The fact of the matter is disciplinary council should have filed a motion to compel if it wanted those records. In the vast majority of cases that disciplinary council litigates with regard to getting people's trust records, they don't, from my review of the cases, they never have the employees or the lawyers' internal records. And as a consequence, they have to bring these cases based on the bank records. And when they bring those bank, they fail to get a motion to compel. And on that grounds, we submit.
Okay, thank you very much, Mr. Doman. Mr. Link, you've got Mr. Turner, if you could. Yes.
Sure. Mr. Prayam, when you asked the question about that transaction report, I hope you carefully understood the answer. That report was not produced by the bank. As Mr. Doman pointed out, there were transactions on that report the bank would not have known anything about. That report was produced elsewhere and purported to be by the bank. And the testimony at the hearing, which remained uncorrected, was that it was produced by the bank, when in fact it was not. And when it was produced to disciplinary counsel beforehand, it was done so with the assumption and under the auspices that this was in fact a bank document. The ABA ethics opinion that Mr. Doman refers to, and I'm second to none in my appreciation of ABA ethics opinions, but it doesn't really apply to this case because in fact, when, as Mr. Hora pointed out, when you are subpoenaed to produce documents in a disciplinary proceeding according to law, you have an obligation to do so. Rule 1.6 makes that clear as well. Mr. Doman's referring to the ethics rules. Look to 1.6. What's interesting here, Mr. Doman at no point ever identified any particular client or any particular transaction as to which he thought they should be protected either by attorney-client privilege or by confidentiality. And in fact, under the DC rules, the information he was trying to protect at best would be considered secrets under 1.c, which of course would not be entitled to the kind of withholding he was attempting to make. In response to your question at the end of, can I just one point, because in response to Ms. Prayam's question about a citation for the commingling in the trust account, our DC Exhibit 20A, Disciplinary Counsel, and in the transcripts at page 83 to 97, page 118, and page 443 to 44, references to the settlement money that was held in this IOLTA account while other transactions were taking place. This is, as I'm sorry, I interrupted. Was that Ms. Cassidy?
No,
I'm sorry, Ms. Pittman.
But proceed.
Okay.
Mr. Link, before you do proceed, I want to follow up with one question on Bradley. You argue that we are able to apply a de novo review of dishonesty. Under Bradley, is that review limited to a sanctions analysis?
That's a great question.
Thank you.
In order to get to a sanctions analysis, you have to first make a finding with respect to what are the applicable facts and the conclusions applicable to those facts. So I don't think it's as easily separated as that might suggest. I do think, however, it influences sanction. And as is clear, we're asking for a suspension in this case. At the hearing, we asked for disbarment, and we're asking for a 1-year suspension. We did not take exceptions to the 1 point finding with respect to 1.16 and the finding with respect to 1.4. The reason we didn't is because we wanted to focus the board on those issues as to which there is, in our view, beyond a doubt, clear and convincing evidence. And we think with respect to the charges remaining, there is. On the question of the time limits missed in the employment discrimination matter, again, I just refer you to the record. I just refer you to the failure to respond to the adverse motions by the government on behalf of his client, the failure to seek discovery in a timely manner, and then to seek discovery and to ask for extra time to seek discovery. One of the other interesting findings of the hearing committee, and I think I said it was finding, I gave it in my list of findings earlier, is that I think it's finding 46. Lawyers have many opportunities to and can refuse to seek discovery as a tactic. That this was no tactical decision in this case. This was a failure to act, which the lawyers sought to remedy. Mr. Chairman, can I have a moment of personal privilege?
I think has a question. I think she'd like to get answered before the.
I'm sorry, Ms. Priya.
No, the virtual screen, I think, sometimes make it difficult. On commingling, the investigator of the disciplinary office testified that he couldn't establish whether any of the funds in the IOLTA were entrusted funds. If the board were to credit that testimony, my understanding is that you are arguing, relying on that Ching case, that you can establish commingling if the respondent is unable to identify which funds in an account are his versus the client's. Why isn't that impermissible burden shifting?
Well, because the client has the respondent has a fiduciary obligation as a trustee to maintain these accounts separately and to maintain records that demonstrate what is in the account and that he is not commingling his funds. Here, we have evidence that he was using his IOLTA account for personal expenses. There is evidence of settlement funds deposited into his IOLTA account. With respect, that's what's necessary to show commingling. Commingling it's clear from the cases that the burden is on every lawyer to demonstrate they're acting with the high level of fiduciary duty that as a trustee, and clearly that was not evidenced here.
I gave the respondent, well, we wound up having about a minute to wrap up. Mr. Link, if you'd like to take about a minute to wrap up as well, then we'll.
I have wrapped up. One point I did want to make. These are always charged proceedings, and it's in the nature of this proceeding. And this one, perhaps a little more so than most. I haven't seen Mr. Doman for over a quarter century, and the last time we saw each other, it was under much more pleasant circumstances than this. And I noted that in his reply, he has a footnote where he points out that I wrote letters of recommendation to him when he was applying for judicial clerkships. And I'm very proud of that. I'm very proud of being able to help young lawyers go forward. I had completely forgotten that. And so in our brief, I didn't mention that, not because I was trying to hide anything, I just had forgotten it. But I'm glad of that fact. And I'm sorry that this is where we are today, a quarter century later. But this is where we are today, and I urge the board, your decision in this case is important to show that the same rules apply to everyone, and if we're going to be true to our responsibility to protect the public and to protect the administration of justice, we have to be, no one gets a free pass with respect to certain conduct.
Okay. Thank you very much, Mr. Link. Mr. Doman, the case is submitted. Have a good day, everybody.